And that being said, we want to welcome you to Alternative Options to Guardianship webinar. And I'm going to pass it off to Sarah from the ADDPC. Here you go.
Well, welcome everyone. We are really excited to have some great presenters on board with us today. We're tackling an important topic, and the council, we get a lot of emails and phone calls and messages about guardianship and whether that's really the best fit for families and what the alternative options are to what can be a complicated and confusing and scary process for Arizona families. Here at the council, we like to think of ourselves as champions of an individual's independence. So we want to talk about the alternative options to what can be a really restrictive process. And so we have brought in some experts on the topic, and they're going to talk about the whys and the hows of guardianship and the other paths families can take for us today. So a little bio to start off with. Our first presenter is going to be Dr. Susan Marks. Dr. Marks is a professor of special education at Northern Arizona University. Her passion for advocacy inspired her to go back to school and earn a law degree a couple years ago. She has worked in residential, rehabilitation, and school settings with a specific focus on autism and individuals with complex needs. She also happens to be very passionate about supported decision making. Following Dr. Marks will be one of our council members, JJ Rico. JJ serves as the Executive Director for the Arizona Center of Disability Law, which is a public interest law firm which offers free legal services to individuals with disability rights cases. He's been with the center for about 15 years, working his way up as a staff attorney to litigation director, and now as the Executive Director. So I'm going to hand the reins over to Susan now, and we'll get things going. Thanks, everyone.
Hi everyone, can everyone hear me? I'm hoping that you do. My name is Susan Marks, and as Sarah was saying, I am passionate about this issue, and one of the reasons is because I have been working with families and when their children are younger in order to get quality education for their children. And then I also have worked with adults who have developmental disabilities and have found that the adulthood issues are really critical for quality of life. After all, we are adults much longer than we are children. So I began to look at some of these issues around guardianship and how that affects an individual's quality of life. So I was happy that our first webinar on this series is on the alternatives. Oh, okay. So a little bit about some of the evolving context of why we're now beginning to really look at what are the alternative options to guardianship. Because in the past, people generally felt that if someone had an intellectual disability, they really should have a guardian for their own protection. And now we're finding that because of the historical movement, away from institutionalization, that we're beginning to embrace the concept of inclusion and least restrictive environments, and that we're beginning to now really focus on the civil rights. It's a different way of looking at civil rights, but there's been enough legislation where we're beginning to question how do our practices support the civil rights for individuals with disabilities. And in schools now, we're also beginning to focus more on self-advocacy and self-determination. So how do our practices influence and fit in within this evolving context? And I always like to start my presentation when I talk about guardianship on the changing views of support and how this really matters as we start thinking about how we want to continue to support individuals with intellectual and developmental disabilities. So we're going to have you watch this Credo for Support. It was created by Emma Vandercliff and Norm Kuntz.
Throughout history, people with physical and mental disabilities have been abandoned at birth, banished from society, used as court jesters, drowned and burned during the Inquisition, gassed in Nazi Germany, and still continue to be segregated, institutionalized, tortured in the name of behavior management, abused, raped, euthanized, and murdered. Now, for the first time, people with disabilities are taking their rightful place as fully contributing citizens. The danger is that we will respond with remediation and benevolence rather than equity and respect. And so we offer you a credo for support.
Do not see my disability as the problem. Recognize that my disability is an attribute.
Do not see my disability as a deficit. It is you who see me as deviant and helpless.
Do not try to fix me because I am not broken. Support me, I can make my own contribution to the community in my own way.
Do not see me as your client. I am your fellow citizen. See me as your neighbor. Remember, none of us can be self-sufficient.
Do not try to modify my behavior. Be still and listen. What you define as inappropriate may be my attempt to communicate with you in the only way that I can.
Do not try to change me. You have no right. Help me know what I want to know.
Do not hide your uncertainty behind professional distance. Be a person who listens and does not take away my struggle from me by trying to make it all better.
Do not use theories and strategies on me. Be with me, and when we struggle with each other, let that give rise to self-reflection.
Do not try to control me. I have a right to my power as a person. What you call non-compliance or manipulation may actually be the only way I can exert some control over my life.
Do not teach me to be obedient, submissive, and polite. I need to feel entitled to say no if I am to protect myself.
Do not be charitable towards me. The last thing the world needs is another Jerry Lewis. Be my ally against those who exploit me for their own gratification.
Do not try to be my friend. Get to know me. We may become friends.
Do not help me even if it makes you feel good. Ask me if I need your help. Let me show you how you can best assist me.
Do not admire me. A desire to live a full life does not warrant adoration. Respect me, for respect presumes equity.
Do not tell, correct, listen, support, and follow.
Do not work on me. Work with me.
Do not look on me. Look with me.
She's not a word.
This video is dedicated to the memory of Tracy Latimer. Written and produced by Norman Kuntz and Emma Vanderclift. Introduction spoken by Emma Vanderclift. Statements spoken by People First of San Luis Obispo.
So, keeping in mind this credo for support, I believe captures much of what we're talking about when we talk about alternative options to guardianship. By the way, you can access that video by just going onto YouTube and Googling a credo for support. So as we think about alternative options for guardianship and the next movement on supporting individuals with keeping these principles in mind, we begin to think about, or it requires us to think about, how can we support an individual to have their own voice and to have as much self-determination as possible instead of us imposing our desires to support on the individual. So with that in mind, what is a guardian? The courts appoint guardians to care for people who cannot take care of themselves. So that in itself already imposes a view about the individual that they are not able to take care of themselves. And unfortunately, oftentimes this may lead to some consequences that we didn't intend. So guardianship before and now. As I began to look at the national core indicators, so here's some numbers for Arizona and the national average. And we see the types of disabilities where people are more likely to have a guardian. We also see from these numbers that full guardianship is more common than limited guardianship. And yet, we have three sources that are asking the professionals and asking governments to take a look at whether guardianship is the right option for many individuals. So if you look at just the position statement of the American Association on Intellectual and Developmental Disabilities and the ARC, their position statement says, the appointment of a guardian is a serious matter for two reasons. One, it limits a person's autonomy, that is the person's choice of how to live and from whom to carry out that choice. And two, it transfers the person's rights of autonomy to another person. So the position statement is that the majority of people with intellectual and/or developmental disabilities can manage their own affairs with informal assistance and guidance from family, friends, and others. So when necessary, people should be aware of and have access to preferred alternatives. If guardianship is essential, it should be used only to the extent necessary with a presumption in favor of limited rather than full guardianship. TASH is another group that has come out with a resolution and on alternatives to guardianship. And they say guardianship represents at best a removal of fundamental rights and a lifelong diminution of a person's basic control over his or her own life. Guardianship is, at its core, incompatible with real self-determination and full citizenship, and is therefore incompatible with the principles of TASH. And then finally, the Convention on the Rights of Persons with Disabilities, Article 12, stresses the importance of that governments recognizing that persons with disabilities enjoy legal capacity on an equal basis with others in all aspects of life, and that government should take appropriate measures to provide access by persons with disabilities to the support they may require in exercising their legal capacity. So in other words, whereas guardianship takes away support oftentimes because the individual now has somebody else making their decisions, most of these organizations are stating that we should be supporting individuals to basically make their own decisions without the need for a guardian. So I've been asking myself why this happens so rarely, and that actually the research is showing that there's been an actual increase in the appointment of guardians. And particularly over the last 10 years, this increase has been rather dramatic. I believe that, well, part of the research is also saying that one of the reasons is that school personnel oftentimes lack knowledge of guardianship. So during the transition planning, oftentimes school teams will encourage parents to go and seek guardianship as the student is getting ready to turn 18. So oftentimes the parents will feel alarmed and feel worried, and that's probably when they're calling Sarah at ADDPC as well as ACDL, because these parents just came out of a transition meeting and found that they should be seeking guardianship. The other reason I believe that the increase in guardianship is because as a society, we are still continuing to perpetuate this view of what Norman Coons and Emma Vandercliff termed disability spread. In other words, we oftentimes think that a person's disability is what defines them. And so we look at everything as far as their capacity or their ability to make decisions through that lens of disability. And over time, the disability becomes more about the person than the person themselves. So here are some of the issues and why we are presenting today on some alternatives. Guardianship tends to be a blanket decision during the post-school transition planning. There's an all or nothing thinking that you either need guardianship or you don't. That, as you saw from the charts that I presented earlier, limited guardianship is not often used, but in our state, limited guardianship also is not so limited. Oftentimes, limited guardianship only preserves the right of a person to vote or some other smaller aspects of their civil rights. There's oftentimes a payment or some additional expense for guardianship services. There's a huge disconnect between the goals of schooling and post-school environments. We want individuals to have a quality of life, to learn to be self-determined, and then at 18 we tell them that they need a guardianship. There's also a lot of bureaucracy with the guardianship laws and the process of guardianship. So there's a huge loss of autonomy. In fact, people have been finding that once a person has a guardian, it's very difficult to have a guardian removed or for a person to be determined as not needing a guardian. Here are some of the unintended consequences to the individual. Obviously, there's a loss of basic civil rights and civil liberties. People don't realize that once a guardian has been assigned, the person may lose a lot of the basic rights that we take for granted, such as who you can associate with, whether you can marry, where you can live. And as I mentioned earlier, the perpetuation of there's a disabling view by society. So when someone has a guardianship, there's a tendency to view that person as more disabled than they really may be. The person themselves may feel disempowered. And I have seen this sometimes with some adults where they feel I have to ask my guardian, I can't make that decision. There's also a failure to recognize changing needs. Like I said, when a guardian is assigned or a court awards a guardianship, it's very difficult to have that guardianship changed, or maybe changed to a limited guardianship, or changed to the person not needing one. Obviously, there's a potential for abuse and exploitation. In some ways, I think that ties in with that feeling of disempowerment and loss of control. If the individual doesn't feel that they have the right to speak against the guardian or to make their choices known because they have a guardian, there's a greater potential for abuse. And as I said earlier, huge difficulty with changing the guardianship status because people have to go back to court. So what needs to happen? My hope, as I teach pre-service teachers at the Northern Arizona University, is I've been explaining to pre-service teachers that there needs to be a stronger connection between school and adulthood goals. In other words, if we're going to want individuals to be self-determined, we need to start teaching that much earlier. Also, in transition planning, we should be looking at what those needs are and how to help a person not need a guardian once they turn 18. And also we need to encourage use of alternatives to guardianship, but obviously part of that is becoming aware of what those alternative options are. And I also think it's very important that people understand that mental capacity is not the same as legal capacity. Because if it was, maybe a lot of us would not be considered as having legal capacity. Because mental capacity is one thing, but legal capacity is a very minimal standard. It just is basically that you can make your own decisions with some help. For those who have guardians, I think it's very important that we begin to start thinking about monitors and advocates in order to check in with the individual, again, in order to make sure that there's no abuse or a person is not being listened to. As we shift from looking at these alternative options, when we talk about young children, we oftentimes use the term in the best interest of the individual. And I believe that as we start thinking about adults, we should be thinking about what is that person's actual wishes. Many of us make decisions that are not in our best interest, but we have the freedom to make them. And making a distinction between making decisions for and making decisions with. And thinking of this in terms of not black and white or all or nothing, but that in some areas with some support, a person should be able to make decisions in certain areas, and in other areas they might need more support. As others who have spoken about supported decision making have said that we all tend to do this. We have a sliding scale of abilities. Some of us are good with doing our taxes, and some of us go and hire a CPA to do it. So these are some of the ideas about how to get there, starting early, person-centered planning, exploring these alternatives that JJ is going to be sharing with us next, build in advocacy supports, and also work to change some of the policies, and that will be with the legislature, to begin to start conveying a view that individuals should be able to make decisions to the extent that they are able to with supports rather than having a guardian. Okay, I'm going to hand this over to JJ. He's going to go over alternative options.
Great, thank you, Susan, and thank you for all the good information. We at the center, I want to be clear of the goals, mission, and vision of the Center for Disability Law so that all folks on the phone, on the webinar, understand the nature of our law firm and our protection and advocacy status. And so, although we are a law firm, we do not represent folks in establishing guardianship or any probate matters, but we do advocate for the independence of the individual. And I think if I were to take anything away from Susan's remarks earlier, it's really focusing on the individual. And that goes along with the Center for Disability Law's vision. Our vision for the future is a society that focuses on one's abilities rather than disabilities. And I think that's really, if we were to take away anything, or if I'm taking away something from today, it's focusing on the ability of the person with the disability rather than the disability or the diagnosis. Being a parent of a child with a disability, I'm constantly asked, well, what can your son, starting with what can't he do? And I always try to change the conversation to focus on what he can do and how he's more typical than someone might imagine, just because he either has a label or may appear different or sound different when he attempts to speak. And so as a parent and as a director of an agency that advocates for the least restrictive option, it gives me great pleasure to talk to all of you today and to talk about some of those alternatives. I already see a question from someone out there with out in the community saying that DDD is requiring guardianship. Well, I'd like to learn about that some more, but I'd also want to say there are alternatives that can still maintain some decision making by a parent or by a guardian, by a designated person without full guardianship. So again, I'm hoping that you all learn some of those alternatives today. I'd also like to share that we with DDPC and other agencies developed a legal options manual that contains some of this information. It's currently in the process of being updated, and once updated, we will release a new updated version that's reflective of any changes in the law. But there is a manual that exists right now that discusses some of these, but it is in the process of being updated. So what I'm going to share with you today are those alternatives and the specifics about how to proceed with one of them. You should consult with a private attorney if one of these fits the needs of your child or the needs of one of your family members. So again, with that, please focus on what's on the best interest of the individual. And there also might be, I'm going to talk about a number of options, and there might be a few of these options that you might need at different stages or when working with different agencies. So let's start. So I think the other things to ask is questions of who, what, and how. And so these are the items that we're going to talk about. Representative Payee, designated representative in voc rehab or vocational rehabilitation, etc. So this slide will show you all of the areas that I will talk about, that there are alternatives to full guardianship if you're dealing with these agencies or the unique needs of your person who you're with in your family or your child maybe. Maybe they might need one of these, or as I said earlier, might need more than one. So let's start with Representative Payee. If your child may receive Social Security, SSI or SSDI, the Representative Payee is the person who would accept that income on behalf of the person with the disability, and they receive that money to manage the money for them. How would they go about doing this? There's a form, and I know the form's also available online at the Social Security website or at the Social Security Administration office. That person then can set up an account both in the individual's name and also the Representative Payee's name, and then they're directed on how or what they should be using that money for. And so if you are concerned about maybe your child's ability to manage money, or if they were to receive their Social Security check, they may be subject to abuse or someone may take advantage of them. This could be an alternative where you can still control the money in a way, but still use it for the purposes that they need. And so this is an alternative in case the concern you have is someone receiving a check, $730 and not knowing what they might do with it. If you have facts to show that they have not been able to manage money after implementing some of the steps that Susan recommended of giving them those practical skills, then this might be an alternative. But again, giving them the skills first and see if they're able to manage their money, and then go to the alternative if that's what's needed. The designated representative in vocational rehabilitation. Susan pointed out that a lot of folks maybe on the webinar today are the first time they're being presented with you need a legal guardian is during transition planning, or maybe when during the transition plan there's a discussion of vocational rehabilitation services. And so you can designate a representative in working with vocational rehabilitation. And so that person, the person who may need this is someone who needs help navigating the VR process. If you are not familiar with vocational rehabilitation, it's a state agency that receives federal money to provide employment services to persons with disabilities. That could be a range of different things, and it first would be, if they qualify for the services, is developing an IPE, not an IEP. It's an employment plan where someone sets a goal and says, I want to become I want to work with animals, or I want to work in a veterinarian's office. And so they set a goal, and then they develop steps and skills and training, and maybe a job coach is needed. So in that plan that's developed, that person and VR work together. Now, if the person in your family, and we'll use my child as an example, needs additional assistance in that process, we could complete the form that exists that's a designated representative with Voc Rehab. And so that person would protect their rights in developing that individual plan for employment, or the IPE. And so how do you do that? You can notify VR Voc Rehab counselor in writing, and you might also want to reference a form that we will update in our new legal options manual. So that could be something that you would want in case the person in your life is needing help with the vocational rehabilitation system. If you are, if the person in your life is a person with a mental illness and needs mental health care, there is also a designation where you can designate a representative in mental health care. And so we have in Arizona regional behavioral health authorities, or RBHAs, RBHAs. And if you're a member who requires help asserting your needs in treatment and or other related processes, such as medication or a plan, a healthcare plan, you can designate a representative to act on your behalf in staffings, planning meetings, maybe during a grievance if one were to arise, or the appeals process if that were needed. So in that situation, you would want to notify again the RBHA in writing and let them know that this person is the designated representative of the individual in mental health, in their mental health care. Now, this is probably a big one for a lot of folks. When your child reaches the age of 18, I know my child's not yet 18, but I know that I participate frequently in his IEP meetings at least once a year, and if there's an issue and we need to convene another meeting, I'm there along with my spouse, and we are obviously developing an IEP or discussing his educational needs. But at the age of 18, the school district could say that you shouldn't be there, and they're 18, they're a majority, they need to make the decisions on their own. Now, if that's what you're being told, you can delegate, or that your child could delegate their rights to make educational decisions. That's for students who are the ages of 18 to 22 years old, receiving assistance through an IEP or an individualized education plan. And so that would designate, make them authorized to make educational decisions on behalf of the student. How would you do that? You would notify the school personnel on the student's IEP in writing with the student's notarized signature. So again, that one I'm sure comes up in many folks' life, and they might be concerned of, or have been told, as Susan said again, in an IEP meeting that, oh, you're going to need to get guardianship. And this clearly is not guardianship. This is just delegating those educational decisions for that person in special education. So that this is something that should be used frequently if you're ever faced with that, and the school district should honor that. And if you counter any barriers from the school district not honoring that or not allowing you to participate after letting them know in writing and having a notarized signature, you most definitely could contact our office or another office like ours or Susan's office and letting us know that the school district has now not accepted that delegation of rights. Other things that folks think about or want to have are advanced directives and living wills. Who would want that? Somebody wants to direct their healthcare decisions now or in the future. Sometimes, obviously, when someone is in a certain medical state, they may want to delegate those decisions, or they may want to delegate those decisions in the event maybe the individual, for example, my son may not be able to make decisions for his health care in certain times. And so you can complete an advance directive or living will depending on the status of their health. And so this does delegate certain types of decisions to someone, instructing them what needs to be provided. And so sometimes that's, folks hear about that, or you may become familiar with that when someone says, I don't want any extra measures taken when I'm in a certain state. I don't want life support or those type of things. The Attorney General's office, I believe, still has forms on their website, or you can also, physicians and I know doctors' offices or hospitals oftentimes have the forms that can be completed. A lot of times I've been presented those forms upon check-in for family members of mine and asking if those were on file or if I wanted to complete those. So there are different types of directives and wills. There's healthcare advance directives, durable healthcare power of attorney. So again, the advance directives are kind of that what measures should be taken if you're in a certain state of health. A durable healthcare power of attorney, healthcare decisions, whether or not to proceed with a procedure or not. And again, that is short of a guardianship. Mental health care advance directives or durable mental health care power of attorneys, those also come with some authority to administer mental health care or other decisions. And then a living will, depending on whether or not someone wants certain steps taken on their behalf. And again, I would recommend, if any of these are of interest and you want to thoroughly understand your rights or understand your child's rights, if you were to have one of these, I would urge you all to please consult with a private attorney so that you understand the ins and outs. Purpose for me today is to give you the options and show that there are options and alternatives to guardianship, but I'm not able to give direct legal advice on these, especially in a webinar form. So I would urge you all, if you do think one of these or multiple might work for your child, please reach out to a private attorney. Now, a power of attorney. Who would a power of attorney relate to? It's someone who needs help with certain financial matters. Again, what is this? It delegates special financial responsibilities to an agent. And so again, that could be many different individuals. It doesn't have to be a family member. You can contact any financial institutions where accounts are held for forms or prepare a power of attorney form. These can be found many places. And again, depending on what you are trying to get power of attorney of, if it's for a bank account, you want to make sure that then you're using the proper bank form. Some power of attorneys are overly broad, and so you should be leery that there's a lot of options or a lot of boxes you can check. And so some of those may apply to the situation you need to have power of attorney for, and some might not. And so again, you want to check those and make sure that, again, our objective is you check the least amount possible. But again, you want to apply what your needs are and what the individual's abilities are and put those two together and complete the power of attorney to match both of those. A conservatorship. The person with significant assets that needs those to be protected due to the person's inability to manage. Again, another option for someone who may need some type of oversight on their dealings with assets, and the conservator would act as a financial manager, overseeing all financial matters. So again, something broader than a power of attorney, and much more than our first option related to the representative payee. This does require court intervention and accounting, so you would most definitely want to seek a private attorney and get some good legal advice on how to proceed with the conservatorship. Now again, guardianship, we talked about it earlier with Susan, so I'll just briefly just say again, who would this would be someone that may lack the ability or to make or communicate responsible decisions concerning life's most basic needs, what someone has chosen to make certain decisions in the best interest of that individual, and then how it requires court intervention, accounting, and some counties provide extensive assistance if you're proceeding with this. But again, as you can see in the way that I laid out the slides, the guardianship is at the tail end of all the alternatives. In some situations, you might need multiple of the least restrictive or the alternatives in lieu of a full guardianship, so or even a limited guardianship. There's also the availability of trusts. So a trust, the person would be maintaining the financial eligibility for government programs such as Social Security. Also, funds are available for some other source. Trust set-asides, money that can only be used for certain purposes. Sometimes these are referred to as special needs trust. This does require some significant legal advice depending on the benefits. If your child may receive certain benefits, there might be income or asset requirements that are looked at, or thresholds or ceilings. And so you would want to make sure you're consulting with a private attorney to make sure that if you're establishing a special needs trust, that it's established in a way that obviously makes sure that your child or family member is taken care of, but at the same time that their benefits are preserved. And something that is now been passed in law is an ABLE account, allowing an account to be set up for an individual on some of these benefits, and that would require a whole separate webinar, and maybe that's something next that the DDPC would like to do. But I think that would be something we most definitely, a lot of folks would want to hear about. So I won't spend time on that today. And then what happens if my legal representative becomes unavailable? It depends. If a person gave away the right to make certain decisions, then they freely can designate someone else to make those decisions. And if the court took away a person's right to make then the court would be involved in choosing someone new. So that may come up. So Susan, I'm going to pass the microphone back to you.
Okay, I'm back. Thanks, JJ. So one of the things to keep in mind with all of those alternative options is when you're thinking about the individual for whom these options might be appropriate, is to first list what are the areas of need. So when we do person-centered planning, you might want to think about, does this person have difficulty with managing their money? So what you're doing is you're tying an alternative option to a particular area of need. And of course, you would then be asking, well, would this be an appropriate alternative with supports? The idea behind all of those alternatives is that they're freely entered into because they require the signature of the individual who is receiving the support. So there's a negotiation. There's a process of talking with the individual. For example, if you want that, if you felt that an educational decision-making form should be completed, there's a conversation that happens with the individual, and then that individual says yes, and then signs the form. So these are all situations in where there's an aspect of supported decision-making involved, because now it's not I'm going to do this and not consult with you versus I need to consult with you and get your permission and your signature authorizing me to make your educational decisions or assisting you with your medical decisions or assisting you with your financial decisions. So rather than jumping to guardianship, which, like we said, was all or nothing for the most part, you would look at all of these options and go, what particular need would this option take care of for the individual that I'm considering might need some additional support? And I think that transition teams oftentimes don't do that. And of course, if one of the issues was financial decision making, well, what are the aspects of that, and what can we begin to put into that student's transition plan to help them so that they don't need as extensive level of support by the time they reach 18. The other thing that when JJ was going over all of those forms is to keep in mind, the person has to be 18 in order to sign. So you can't do it early. You can't do it like at 16, 17. The person is considered having legal capacity once they turn 18. So that is at the point where they can freely sign those documents and grant or delegate some of that authority to an individual that they trust. And it doesn't all have to be the same person. So one of the things that's kind of exciting that's been happening in the area of providing supports for adults with disabilities is this concept of supported decision making. I just attended a webinar yesterday on this topic, and you can probably find many webinars that are now promoting the idea of supported decision making as an option to guardianship. So there are 4 primary characteristics. The individual retains the legal decision making authority. In other words, they're the ones that get to sign. They can either enter into it, and they can also freely terminate it, which is different from a guardianship where that's court imposed. Like JJ was saying, the court authorizes that, so therefore the court has to be the one to determine whether it is no longer needed, the guardianship, or whether to assign it to another individual. Whereas with the alternatives, the options that JJ shared, those can be freely entered into and freely terminated. The individual actively participates in the decision making. So in other words, it opens up, again, a conversation between the individual, and the individual then begins to feel empowered that they are in the driver's seat, they are making the decisions, and of course, if they trust you as a support provider, they will probably go with what you would recommend or suggest, just like we oftentimes turn to trusted individuals when we're making a big decision. And if we trust that individual, we oftentimes will consider, and if that person really explains the pros and cons, as well as explains to me, explain to the individual what's happening, then you're learning in that process. But you also feel empowered because it's not someone making the decision for you, it's the person is involving you in that decision. And the concept of supported decision making is that whatever decisions are made are legally enforceable. And so the individual who signs any of those delegations or signs any other form that grants the support person some authority, that they are able to legally enforce whatever decisions are made. Okay. So here's a resource that you can get on their mailing list, their email list, and it's called the National Resource Center for Supported Decision Making. And what's nice is that on that site, you can also click on the links and find out what the guardianship laws are within each of the states, as well as get some really amazing resources on how to engage in a supported decision-making process. There's also a link, or you can email the individuals on that website in order to ask questions if you're having questions about how to engage in a supported decision-making model. So the idea of supported decision-making is that instead of asking if the person needs a guardian, we ask how can we support the individual to be self-determined and preserve his or her civil rights to the maximum extent possible. And I think that even though limited guardianship preserves an individual's right to vote, how often does the individual vote? Really, it's the daily decisions that affect a person's quality of life. Can they choose who they're going to see? Can they choose where they're going to work? Whether they need to enroll in a certain vocational program or another one? Do they get to make a decision about whether they're going to marry or whether they can enter into a sexual relationship with another? And these are like basic civil rights that oftentimes a person loses when they have a guardianship imposed. So instead of asking if, let's begin to ask how can we support? And again, that's part of the transition planning process and should begin at the school level. So I want to share a few years back, there was a woman named Jenny Hatch who really brought the whole concept of supported decision-making to the forefront. And I like to share her story because it helps us to begin to understand why there's such a need for for alternative options to guardianship. Okay, so we'll watch this video.
What's next for Jenny Hatch, who is now home with her friends and back to work after a lengthy court battle with her family.
For nearly a year, we have reported on the struggles of Jenny, a 29-year-old living with Down syndrome. On Friday, Tell It Your Side was there when a judge ruled Jenny can live where she wants to. Now her home is with her friends Kelly and Jim. Andy Fox has been on this story since the beginning, and today he caught up with Jenny for the next chapter in her life. Andy?
Nicole and Tom, that video we just showed is so priceless in all of what it shows and the happiness that it shows. I can tell you firsthand the Jenny trip through the court system has been a wild ride. It wasn't until the very end on Friday that Newport News Circuit Court Judge David Pugh fulfilled what Jenny's supporters knew to be true, that a person like Jenny can have limitations and still be able to make her own decisions, and that's exactly what Jenny Hatch is doing today.
She's here. She's in here. Jenny?
We first met Jenny Hatch last October.
Jenny, I'm doing your story, and I want to know where you want to live.
Yes, I want to live with Jim Kelly.
For the last year, she's been fighting her mother in court to live with her friends, Jim Talbert and Kelly Morris, instead of a group home like her mother wants. On Friday, Jenny won.
Jenny got justice!
Today, we visited Jenny, where she now lives with Jim and Kelly.
Hello,
Andy!
Jenny.
Oh, my God. Oh, my God. Andy, Paul.
It didn't take long for Jenny to show us around her new home, where we found her friends Jim Talbert and Kelly Morris. We went to the outdoor pool where she's planning to have a celebration pool party on Saturday.
Yeah. Where do you like to sit out here?
Everywhere.
A year of court battles now gives way to the quiet solitude of her Hampton home.
You can come on, Kenny.
She took us to her own bedroom.
This is the room.
She has her TV back, her computer, her cell phone, her bed.
This is the bed that I love, and now I can sleep, and it's easy to sleep well. And
you sleep better here?
Yeah.
Pictures of her family.
A family. The
Yeah.
bond that links your true family is not one of blood, but of respect and joy in each other's life.
Sitting with Jenny, you realize how thankful she is.
Did you think the judge was going to rule with you?
No.
No, but he did. Did that surprise you?
I know.
Did that surprise you?
Yes. And I deserve to be home with my own dogs.
On Friday, Jenny's attorney said this case was about judging people by what they can do and not by what they can't do.
Because for everybody who's ever been denied something, ever been told they can't do something, I give you Jenny Hatch. Woohoo! The rock that starts the avalanche.
Jonathan Martinez is legal director for the Quality Trust for Individuals with Disabilities. He specializes in fighting for the civil rights of those with disabilities. Martinez wrote me an amazing email about this subject, and I want to share it with you. Read it online at wavy.com. Tonight at 6, Jenny returned to work for the first time since last August when her court battle began. We were there, that part of the story, and it's very emotional, coming up tonight on Wavy News 10 at 6. I'm Andy Fox, 10 on your side.
So what I forgot to mention, check out that Quality Trust. They've gotten some grant money in order to help people begin to look at how to implement supported decision making. And I put up these quotes because I think that we are sort of at a new era where we're beginning to see that a story like Jenny Hatch really uncovered for us some of the issues around guardianship and our views of people with developmental disabilities. And I don't know if you caught it in the video, but they were talking, this reporter mentioned that Jenny got her TV back. She got her cell phone back. What happened with Jenny was that she was living with these friends, the couple that had helped her and gave her a job. And when she was riding her bike, she was injured. And so her mother began to feel that maybe she was not safe. And so she had her placed in a group home where in that group home, she was not allowed to have a lot of these things that she had. They locked her out of her Facebook page. They didn't allow her to have her cell phone because they were concerned that she would be trying to contact other people. So this led people to realize that sometimes when a person gets placed in a group home or a temporary guardianship, that sometimes these basic rights are ones that we don't really think about getting taken away from us. And so this is why Jenny, with the help of Jonathan Martinez, fought to not have her parents, her mom, have legal guardianship over her. So I oftentimes wonder, what is this going to mean for all of us and our work as we really think about how we can support an individual to have more self-determination in their lives, and which means to direct one's own life. And that it really doesn't mean about protecting the individual, because I know a lot of guardianship is around protection. Does this mean that every individual will be able to engage in this process and pick and choose from all of these alternative options that have been presented in this webinar? Maybe not. But what we're finding is that a huge percentage of individuals probably could benefit from supported decision making, where each of those alternatives are pieced together to address a very specific need, as opposed to having someone make all decisions for the individual. And that we don't really need to have this all or nothing guardianship alternative. Now, I do know that the next webinar in this series later on is going to talk about what the guardianship process is, how to become appointed as a guardian or have somebody else appointed as a guardian. And there are certainly individuals for whom that option is probably going to be necessary. But when you look at those statistics, those charts that I showed earlier, many of those individuals probably did not need to be under guardianship. And the reason that they are is because people are not aware of these options, but they're also maybe not aware of how that affects the person who is who has a court-appointed guardian. So I believe we're going to now turn to questions.
Yes, and I want to move up in the chat thread and relay some comments and questions from Brenda first, and then there's another one from Rita and Andrew after that. But earlier in the thread, Brenda says, DDD demands that we get guardianship, or they will only ask the client what they want. And further stating, not feasible with my blind, nonverbal 17-year-old. And I'll finish her comments. Brenda says, I would love to talk to you more about that quickly. She turns 18 in October, and a few other things as well. That was during JJ's presentation. And to end that posting thread, Brenda says, are there any alternatives to DDD for state services? So I think we can start with that question, and then I can move on to the other ones later in the thread.
Well, I'm not quite sure what the state services are that Brenda was asking about. Alternatives to DDD for state services.
Okay, it looks like Brenda is typing.
Okay.
Oh, she's saying rehabilitation, respite.
Okay.
Attendant care.
Yeah. So a lot of those, particularly if the individual has developmental disabilities and qualifies under that, I don't know of any other state agency that would provide those services. JJ?
I think, if I'm understanding Brenda's question, is there an alternative to guardianship that would allow Brenda, mom in this situation, to represent or speak on behalf of her daughter after she turns 18? If that's the question, I think a designated representative form to see if that could be, if that would be sufficient for the state to allow. If not, I don't understand why a full guardianship would be needed to have some of those discussions to develop, an ISP or some other type of plan. But I don't know one off the top of my head, but I think a simple designated representative for those meetings and for those decisions should work. But I don't know if you've come across that, but I think that's the question. The question is, when dealing with DDD, is there an alternative to guardianship for some of those decisions or some of those discussions?
Yes, and I do know that other families have signed a form, or had not signed the form. The adult could sign the form saying that they're giving permission for their mom or their sister or somebody else to help them with making decisions about DDD services. So DDD has that form. So I think Brenda had two parts. She had a question about the DDD requiring guardianship, and that I have never heard that they would require that. But she's also asking for services through other agencies other than DDD, whether they would pay for it. But I don't know of any, Brenda, other than like Voc Rehab, for the employment services. So there was another question, John.
Brenda says thank you, and then the next one in line is Rita Aiken, and I'm going to read her post. It says, young adults with serious health conditions not previously common in adult health care are routinely entering adulthood and experiencing difficulty during hospitalizations. Their condition may require, and the person desire, the ability to temporarily transfer health care decision-making rights during specific situations, but not related to life-threatening situation or end of life. Is the advanced directive the right tool, or is it the power of attorney?
You want to take that, JJ?
Sure. I think you should look into a medical power of attorney, not the financial power of attorney that we talked about, but you may want to look into a medical power of attorney, and then again, obviously limit that to certain decisions. If you if you know of a person's condition or you know that they're going to have a procedure. So again, I think a medical power of attorney would be the tool you might want to look at.
Yeah, and we all need one of those, right?
Yeah, I think that's a good practice for anyone, because there does come a time, unfortunately, that sometimes we might not be able to make a decision. Those are always good safety measures to have, because honestly, we don't know if we are going to have an accident that renders us unable to make those decisions on our own.
I know that earlier there was, I had looked at the chat box, there was somebody who had said that they needed talk to somebody about guardianship because their child is going to turn 18 in October.
Yes, that was Brenda.
That was Brenda? Okay.
And then following up, Rita asked, would an attorney need to be consulted to draw up the medical power of attorney?
Go ahead.
No. Usually when a person calls me, I just tell them where they can get the form. Usually it requires, the two going in to a notary and having, of course, appropriate ID, and then signing there, and sometimes you might want to bring somebody who could act as a witness. But that's what's so great about these alternative options, is that they don't really have to cost you anything. Whereas guardianship, as people who have looked into that are probably realizing, it can be quite expensive.
And those forms can be found on the Arizona Attorney General's website. I'll type in the address as we're taking other questions.
All right, and lastly, Rita was saying the forms on the AG site are not really appropriate for this use. So,
Okay, let me look. There is a durable healthcare power of attorney. I'll look at it while we're talking. I'll look to see.
Are there particular forms that, Rita, you had looked at that are not really appropriate for what use? Oh, for medical. Okay.
Yeah, I believe the durable healthcare power of attorney would work, and it does. I'll put it there, and I'll paste the link in case that maybe we're looking at two different things.
Thanks, JJ. Moving up again, Andrew Robinson, I think during your presentation, Susan states, Susan, don't forget that if the disabled person makes a bad decision, a guardianship can override that person's decision. For example, if an autistic person signs up for a new phone service, that is really a bait and switch tactic, right? He's asking.
Yes. And that is true, but then that becomes a question of how, when we look at transition planning, if those are potential risks for the individual, is possibly signing up for something that they didn't really need. Is it possible that you could come up with one of the alternative options as opposed to a full guardianship? Because some of these financial issues are entering into a contract. So it is true that a guardianship would be a blanket cure-all for everything, but the problem is it's catching too many of the person's civil rights in that process. So if the person actually needs a full guardianship, then obviously that's a decision that the team or the parents or the individuals need to make. But there are some of these other alternative options that might take care of that particular issue, depending on how frequently it happens too. I know people without disabilities that end up in that exact situation, and nobody would impose a guardianship on them because they signed a contract that locked them into a cell phone service that they no longer want.
Thank you, Susan. Andrew responds, yes, it requires a balance, and maybe people need to be taught how to have balance. Jenny Hatch could have made a bad decision.
Yeah, but we all could make a bad decision. So John McDermott, I'm going to petition for a guardianship for you because that last decision you made was not a good one.
Some days I think I need the help.
Yeah, but Robinson is correct. It requires a balance. But again, when I was on a webinar yesterday, I thought the presenters made a good point, is that guardianship will not take care of every bad decision. So sometimes we have to think about, like, what is the problem and that we're trying to solve through the guardianship, and possibly realize that, well, guardianship wouldn't really take care of that problem anyway.
Thank you, Susan. Later on, and thank you, Andrew, later on in the thread, Julie Montoya stated, I have a woman who needs to have medical testing and possibly surgery. The doctor has stated that he will not perform any of this without a guardian. The woman is her own guardian. Also, she lives on the Navajo Nation, and there is no resource there for guardianship. The state will not appoint a public fiduciary because she does not live in the nation. Any suggestions or recommendations?
Call ACDL.
I appreciate the referral, but I honestly, Julie, I think it does become a disability discrimination matter then.
Yeah.
If the person's their own guardian, why is her decision or her authorizing the surgery not being considered? And requesting that a guardian be appointed, that's not something a doctor should get involved in. Obviously the woman might need to get a different doctor, but that might be too complicated depending on the facts, and access to different doctors might be more complicated. But I believe that would be disability discrimination. I mean, obviously, does this doctor require other patients without disabilities to go under guardianship to make the decision about possible surgery? I doubt it. And so I think Susan's right. All jokes aside, the person could contact us or may want to seek out a complaint of discrimination with the Attorney General Civil Rights Division.
Looks like Julie is typing right now, and there are no further questions in the chat thread.
Okay. And I know it is complicated, Julie, because she lives on the Navajo Nation, but the civil rights issues still apply there.
Julie writes, what would you suggest if she is really not capable of making this type of decision?
So is she capable of signing the medical delegation?
She uses a mark.
So instead of a signature, she just mark.
Julie says, yes, usually we use her fingerprint.
Okay.
If that's her signature, then and she's able to understand the form, I mean, I do think I did see a comment that the durable healthcare power of attorney may not apply, but when looking at it, and I'm looking at it real quickly, so this is a really quick review, but it does say that you can consent or refuse medical care, including diagnostic, surgical, or therapeutic procedures. So if that's her signature, some folks use X's, some use stamps. Again, if she can do that, that could be an alternative, but I guess I'm not sure why, they're making this decision. Is it just because she can't sign her name? But I'm sure this is a lot. We need a lot more information, and unfortunately, we don't have all the time today to get that.
Lastly, Julie says she is somewhat verbal, but will often change her mind when it comes to medical appointments. And then finally saying, okay, thank you.
There is also the last resource, if she is on the Navajo Nation, a resource that's closer that also does similar work to what ACDL does, is the Native American Disability Law Center. So you or her may want to reach out to them because they'll be much closer in terms of geographic location, and they do provide a lot of the same services our office does.
JJ, is that the one, Farmington and Gallup?
Yes.
Okay, I'm going to put the link into the chat area.
Okay.
Julie says, I will definitely contact them. Thank you for your assistance.
Okay, so in closing, I think we're going to wrap things up. I hope that we've given people sort of a pause button when thinking about guardianship, recognizing also that some people may need guardianship and that there are, the next presentation will actually walk you through that process. Okay.
Yeah, thank you all. It was a pleasure presenting on such an important topic.
Thank you everyone for attending our first session today. I want to extend a thank you to Susan and JJ for the awesome information. I loved the videos. And I'd like to remind everyone there in the right hand panel, the file box, we have our legal options manual, which was put together with the help of the Center for Disability Law. I have to tell you, it's our most popular publication. I was packing up manuals today to ship off to one of our DDD offices. This has a lot of the forms Susan and JJ were talking about from the AG's office. It has plain language breakdown of the concepts like durable power of attorney, medical consent, representative payee, a lot of these terms that were talked about today. So I encourage everyone to click on that link. There's a digital printable PDF on our website. And once again, thank you everyone.
And lastly, if you get the chance, please evaluate the webinar at the link in the chat area. We absolutely value your feedback. So thank you very much from ISD.